say that, but I don't think we're fine. I'd like to call to order this meeting of the Commodity Futures Trading Commission. Good morning. The Commodity Futures Trading Commission is meeting today to consider whether 24 specific contracts offered for trading on a number of exchanges, the Intercontinental Exchange, Natural Gas Exchange, or the Chicago Climate Exchange, perform significant price discovery functions. I'd like to start by thanking my fellow commissioners and our staff for being here today. This is our third public meeting this year. I hope to continue holding more of these meetings out in the open. And though over-the-counter derivatives have not been regulated in the United States or elsewhere, Congress did take significant steps in 2008 in the Farm Bill towards closing what was then called the Enron loophole that allowed for trading in energy markets outside of regulation. That legislation required the CFTC to determine whether certain contracts traded on what was called exempt commercial markets, or I'll refer to as ECMs, markets that were really not regulated, served a significant price discovery function in either the regulated futures markets or in the cash markets. So if the CFTC makes such a determination, those markets would be subject to core principles and self-regulatory functions somewhat similar to full exchanges, but not identical, to protect the public from fraud, manipulation, and other abuses. In essence, what Congress did was built upon the important work in essence, what Congress did was start the reform efforts. I think it's essential now that Congress build upon this and have broad reform of the full over-the-counter derivatives marketplace. And the coincidence of this hearing, I do want to say that the Senate Agriculture Committee and the Banking Committee has been working towards broad reform. They put out a package last night on over-the-counter derivatives. I support their strong legislation. It would regulate derivatives dealers with capital, margin, business conduct standards, record-keeping and reporting. It would also promote transparency to the markets by, for the first time, mandating that standardized transactions trade on swap execution facilities or exchanges. And it would also, importantly, lower risk to the American public and protect them against future bailouts by moving the standardized derivatives into well-regulated clearinghouses. This interconnectedness is really at the core, and severing the interconnectedness of over-the-counter derivatives at the core of trying to protect against future taxpayer bailouts. But today, we just are talking about these 24 contracts. And each of the proposed contracts were listed in the Federal Register. I want to thank the public for submitting comments on the proposed determinations. In addition to what we're doing here today, there were 17 other contracts that we'll consider in the coming months. I know the Commission staff is still working diligently to review those as well. The Farm Bill's significant price discovery provisions did close what was then called a loophole that had existed for about a decade, called the Enron loophole, which had excluded the CFTC from regulating trading in certain energy markets. And Congress recognized the danger of such a loophole and what it posed to the American public. 2 years later, as Congress debates essential reform in the over-the-counter markets, we must ensure not to make a similar mistake. Once again, though, I must tell you that certain parties have sought exemptions from regulation in the energy markets, and particularly in the natural gas and electricity markets. But I think the American public needs us to be diligent and learn from their past lessons. We should resist efforts, whether they come from Wall Street or whether they come from industry, to exempt specific classes of contract from reform. History really demonstrates that bright-line statutory exemptions, granted at one point with good intentions, often have unintended consequences later. And that's because markets evolve, and they evolve rapidly. What might seem carefully crafted at one point then leaves problem-filled loopholes later. I think that's really the lesson that we learn from exempt commercial markets. They were created at one point when, as we'll learn from Mr. Berkowitz's testimony, they were really small and in some ways inconsequential markets, and then they grew to be very significant markets. I hope that we can learn from that and not do the same in this legislation moving forward. We determined one contract to be a significant price discovery contract last July, and that authority has been exercised. Today we'll consider 23 additional natural gas contracts and one contract in the carbon markets. I believe staff's recommending that 7 contracts be identified as significant price discovery contracts and 17 not be. So I look forward to the General Counsel, Dan Berkowitz, and our Director of Market Oversight, Rick Schiltz, on their recommendations. But before that, I'm going to turn it over to Commissioner Dunn and any opening remarks.
Thank you, Mr. Chairman. And let me commend you on your continuing commitment to have these types of public meetings. I think it's extremely important that the public industry see how we operate, and I appreciate your effort here. When the initial legislation creating significant price discovery, or SPITX, was enacted, I was under the impression that there might be half-dozen contracts that would fall in this category. The 90-plus ECM contracts initially identified as potential SPITX and the subsequent in-depth analysis in the Federal Register release of 41 of these contracts frankly took me by surprise. I commend the staff on their diligence in carrying out the provisions of the SPITX legislation and thank the public for their comments in the Federal Register release. During my briefing on the SPITX proposal we are considering today, I was struck by the time and effort expended by the CFTC staff to get us to this point. ECMs were created by the CFMA of 2000, and the SPITX determination was mandated by the CFT Reauthorization Act of 2008. If a local trader at an exchange had fallen asleep in 2000 and awoke today, that person would be hard-pressed to recognize the future industry. That trader would probably find himself in an abandoned trading pit. The contract he traded would likely have migrated to an electric platform globally accessed by multi-billion-dollar hedge funds through co-located, algorithm-driven, high-frequency trading strategies. The exchange itself, in all likelihood, would be a publicly traded company closely tied to a clearinghouse whose membership is made up of closely entwined global financial institutions. Many of the changes in the future industry have occurred since I was sworn in as a commissioner in December of 2004. Since that time, we have also witnessed a financial meltdown that has made us acutely aware of some of the inadequacies of our current regulatory system. Despite the fact that the CFTC has made structural changes since the adoption of the principle-based regulatory regime in 2000, this agency has simply been outpaced by an ever-evolving industry and consistently asked to do more with less by Congress. Today, while we are still working through the congressional mandates of our 2008 reauthorization, legislation that calls for more regulatory control will place greater burdens on the agency as working its way through Congress. Unfortunately, I do not know if we're ready for what will be asked of us. My fear is that the trader who fell asleep for 10 years ago and woke up unable to recognize the modern futures industry was easily able to identify the CFTC because we haven't changed that much. I believe it is time for the CFTC to undertake a complete restructuring to put it more in line with today's regulatory needs. We need to accomplish a business re-engineering of the agency that reflects the demands of what Congress and the public expect of a futures regulatory agency. Greater emphasis needs to be placed on such issues as consumer protection, global harmonization, regulatory information sharing, risk assessment, high-frequency algorithm trading strategies, and interconnectivity of industry institutions. As Congress works on new legislation, we must begin to think about structural changes at the agencies to handle the regulation of swaps. We will need to develop the technical capabilities that will be needed for today and the future. We must begin planning now for the oversight that we will need to regulate exchanges and clearinghouses that will be offering services to accommodate swaps and products as yet undeveloped. Now's the time to take a look at the structure of the CFTC. Now's the time to determine what it will take to become an effective regulator in a modern and ever-changing future industry. Again, I want to thank the staff for their work on these contracts and for helping me realize what needs to be done in the future to ensure that we remain an effective regulatory agency.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you. Good morning. The appropriate regulatory treatment of contracts traded on exempt commercial markets has been an important and evolving issue for the Commission from the time Congress authorized their existence in 2000. And initially, ECMs were subject to basic record-keeping and reporting requirements for contracts averaging 5 trades per day or more. And the Commission could demand the production of additional information under its special call authority when appropriate. The Commission was also authorized to determine that an ECM contract performed a significant price discovery function for an underlying cash market. Such a finding did not, however, trigger any self-regulatory responsibilities for the ECM or any additional oversight authority for the Commission. In addition, while the information received from ECMs was somewhat useful to the Commission, it was not transmitted in a form that could facilitate regulatory oversight, such as our large trader reporting system does. As ECM markets developed over the past decade, the Commission recognized that additional oversight authorities were needed or potentially needed for price discovery contracts traded on ECMs, particularly those linked to fully regulated contracts traded on designated contract markets. The Commission found that a similar level of regulation was appropriate for these contracts, not only to give both the Commission and the ECM proper policing authority, but to eliminate possible competitive disparities that could unfairly advantage an ECM listing a contract that competed with a DCM contract but was not subject to the same regulatory restrictions. In 2007, the Commission recommended that Congress amend the Commodity Exchange Act to correct this gap in the law, which Congress did in the 2008 Reauthorization Act. None of the 24 contracts the Commission will vote on today are linked to or serve as lookalikes for the contracts traded on a DCM. Nonetheless, staff recommends that the Commission declare 7 of these contracts as significant price discovery contracts. Staff has determined that these particular contracts are referenced or consulted on a frequent or recurring basis by cash market participants when pricing transactions and thus meet the material price reference criterion for significant price discovery determination. Comments filed during the public comment process have questioned, among other things, whether these contracts are liquid enough to serve as true price discovery vehicles. While that may be a debatable point, I agree with the staff's analysis that not all of the price discovery criteria set forth in the statute must be present to declare a contract a significant price discovery contract, and that the material price reference element is sufficient for the 7 contracts that staff recommends to the Commission to declare to be price discovery contracts today. I will close by saying that I really appreciate all the work that the staff has done here at the CFTC, especially DMO staff, initially looking at these 90 contracts as potentially being SPIDIC contracts, and I appreciate the hard work and look forward to hearing the presentation today. Thank you.
Thank you, Commissioner Summers. Commissioner Chilton.
Thanks, Mr. Chairman. I wasn't going to say anything today because this is a fairly mechanical thing, although I very much appreciate doing it, and I commend you, Mr. Chairman. I think it's a good thing to do these more often, as all of us have talked about in the past. But and you know what you say here in this small room may not matter, but you know, we're here for a reason, and even though you may not be heard, sometimes it's important to just say something that you believe in. And I was thinking as I was coming in today about what's going on Capitol Hill, and all of us have worked up there. And I certainly hope that individual senators have their issues taken care of and they get on with this, because if there's nothing that they do, we are doomed to repeat these failures that have happened. If there's no action on regulatory reform, some of the things that both the chairman and Commissioner Dunn talked about, I think we could be in a world of hurt again. One of the things that we've all probably dealt with, the five of us, when you're on Capitol Hill, the things that tend to motivate, that tend to move legislation forward are disasters. There's an old saying that mine safety rules are written with the blood of miners, and we had that devastation in West Virginia with 29 miners on April 6th. And not to put it in the same category, the financial regulatory reform, as people's lives, but we've had a real disaster with financial markets and people's pension funds and college kids' funds and people making decisions about gas or food, et cetera, et cetera. It is an economic disaster that we've had. And I just hope that Congress, right now the Senate, gets on with it. I want individual senators to be taken care of and the amendment process to go forward. But the status quo is unacceptable, and I sure hope they do it. What we're doing today takes care of part of it. It moves us in that direction. It doesn't deal with credit default swaps. It doesn't deal with some of the things that brought our economic financial circumstances to the edge of the cliff. Some would say, you know, we did a Thelma and Louise and went off. So I'm hopeful that we can do these things today, but more importantly that Congress gets with it and gives us even greater oversight to protect consumers and ensure efficient and effective markets in the future. Thanks.
Thank you so much, Commissioner Chilton. Thelma and Louise, too. Commissioner Malia.
Good morning. Thank you. I want to thank all the staff that have been involved in preparing for today's meetings, in processing the reams of paperwork involved in the significant price discovery contract determinations. As Commissioner Dunn noted, this project has consumed untold staff hours and significant resources to analyze over 90 contracts, of which 7 are recommended here today. From my perspective, it is of paramount importance that the market understands clearly the process determining what constitutes a significant price discovery contract. The Act specifies 4 factors that the Commission must consider in determining, in its determination: price linkage, arbitrage, material price reference, and material liquidity. Congress left the decisions regarding the definition and relevance of each factor up to the CFTC to decide. The guidance provides insight as to how the agency applies and defines these factors, but I question whether the criteria are clear and transparent enough for the marketplace. We must be transparent as possible about the process for making our determinations, and I hope through today's presentations and questions, staff will be able to explain with reliable certainty what these determinations mean and which contracts will be considered SPITX. Thank you again for all your hard work. This is a very difficult process to go through each and every one of these things. I'm sure we've learned a lot about these contracts and what is significant price discovery contract, and I look forward to your presentations.
Thank you, Commissioner Malia. Thank you all the commissioners, and so I think I'm turning it over to General Counsel Berkovitz first, who's going to give us a little bit of a legal background on this. There is a written statement both from General Counsel Berkovitz and Director of Market Oversight Schultz that hopefully is on our website for anyone listening in, but available to the press as well, and you'll summarize. Thank you.
Thank you, Mr. Chairman and Commissioners. My statement briefly discusses the legislative history of the provisions in the Commodity Exchange Act related to significant price discovery contracts. This history includes the creation of a new type of market, the exempt commercial market, under the Commodity Futures Modernization Act, the evolving role of ECMs in the energy derivative markets, leading to an increased need for regulation and oversight of ECMs, and the CFTC Reauthorization Act of 2008, which provided the Commission with authority to regulate the trading of contracts on ECM that perform a significant price discovery function. These are called SPITX for short. I will also describe briefly the Commission's statutory responsibilities with respect to determining which contracts are SPITX. The Commodity Futures Modernization Act, or CFMA, established a tiered structure for regulating commodity trading. The degree of regulation depended upon the type of commodity, the type of market, and the size and degree of sophistication of the participants in the market. The CFMA placed one of these tiers in Section 2H3 of the CEA. Under Section 2H3, the trading of contracts in exempt commodities on an electronic trading facility by large sophisticated parties, known as eligible commercial entities, was exempt from the provisions of the CEA, except for the anti-fraud and anti-manipulation authorities. An exempt commodity is any commodity that is not an excluded commodity or an agricultural commodity. Primarily, examples of these include energy commodities, metals, and carbon instruments. As the Chairman had noted and Commissioner Dunn have noted, at the time the CFMA was enacted, most ECMs were simple trading platforms. The first ECMs did not offer centralized clearing. Early ECM contracts were not linked to contracts listed on designated contract markets, or known as futures exchanges. In just a few years after the passage of the CFMA, however, trading grew exponentially in the OTC market, especially in the natural gas and other energy derivatives markets. ECMs dramatically increased their trading volumes and took on many attributes of a DCM. Some ECMs began to offer lookalike swap contracts that were economically equivalent to futures contracts and whose settlement prices were in fact linked to the settlement prices of their exchange-traded counterparts. Some ECMs also started to offer centralized clearing for their contracts, an option widely utilized by their customers. This increased trading activity and clearing on ECMs raised concerns whether the Commission had adequate authority to protect the markets and the price discovery process from manipulation and other market abuse. These concerns increased following the collapse of the Amaranth hedge fund, which was an extraordinarily large trader in both natural gas futures contracts on the regulated NYMEX market and in natural gas swaps on the then unregulated Intercontinental Exchange, ECM, and which frequently traded between the two markets. As a result of this growing concern, the Commission recommended, and the Congress enacted, legislation to regulate contracts traded on an ECM that perform a significant price discovery function. The CFTC Reauthorization Act of 2008, which was included as part of the 2008 Farm Bill, added new Section 2H7 to the CEA to regulate significant price discovery contracts traded on an ECM. Specifically, for contracts that are determined by the Commission to be SPIDICs, or perform a significant price discovery function, the Act requires that the ECM comply with 9 core principles. These core principles include the obligation to adopt and maintain position and accountability limits, monitor trading to prevent manipulation and price distortion, provide for emergency authority to liquidate open positions and to suspend trading in SPIDICs, and publish daily trading information on price and volume. The Reauthorization Act directed the Commission to review contracts traded on ECMs to identify those that serve a significant price discovery function according to several criteria. These, as Commissioner Amalia noted, include price linkage, the extent to which the contract uses or otherwise relies on a daily or final settlement price or other major price parameter of a contract traded on a futures exchange or other facility regulated by the Commission. Arbitrage, the extent to which the price for the contract is sufficiently related to the price of a contract traded on another regulated facility so as to permit market participants to effectively arbitrage between the markets. Material price reference, the extent to which, on a frequent and recurring basis, bids, offers, or transactions in a commodity are directly based on or are determined by referencing or consulting the prices generated by contracts being traded or executed on the ECM. And the fourth factor, material liquidity, the extent to which the volume of contracts in a commodity being traded on the electronic trading facility is sufficient to have a material effect on other contracts traded on a regulated facility. Not all criteria must be present to support a determination that a particular contract performs a significant price discovery function. The contract may be determined to perform a significant price discovery function even if one or more criteria may be applicable to a particular contract. Moreover, the statutory language neither prioritizes the criteria nor specifies the degree to which a SPIDIC must conform to the various criteria. The legislation directed the Commission to issue rules implementing the new ECM provisions. In March 2009, the Commission issued a final rule to amend Part 36 of the Commission's regulations to specify the criteria on which the Commission will rely in making a determination that a contract is a SPIDC. It also set forth the factors that will trigger an ECM's obligation to notify the Commission of a possible SPIDC, the procedures the Commission will follow in reaching its determinations whether a contract is a SPIDC, and the procedures, standards, and timetables by which an ECM with a SPIDC must demonstrate compliance with the core principles. The 2000 Reauthorization Act also required the Commission to review and issue determinations regarding the contracts traded on electronic trading facilities in operation as of the effective date of the final rule. The Commission is meeting today to make determinations pursuant to this statutory requirement. In particular, the Commission is considering the staff's recommendations with respect to whether a number of natural gas, electricity, and other commodity contracts traded on ICE and the Natural Gas Exchange constitute SPIDCs. Mr. Schultz will describe the process used by the staff to arrive at its recommendations as well as the basis for those recommendations. The ultimate responsibility for making these determinations of whether these contracts constitute SPIDCs rests with the Commission. In making its determination, the Commission may assign such weight as it determines appropriate to the factual evidence presented by the staff. The Commission may also consider and weigh the public comments received in this matter. As previously mentioned, not all of the statutory criteria must be present, and neither the statute nor the Commission's regulations dictate the relative weights afforded the various criteria. In the guidance on this matter in Appendix A to Part 36, however, the Commission indicated that certain factors by themselves, such as the price linkage factor, may not be sufficient to support a finding of a SPIDC. The guidance also states, however, that there is, quote, no mechanical checklist or formulaic analysis, unquote, in considering these factors. Upon making its determination, the Commission is required to issue an order explaining its determination. If the Commission determines that the contract performs a significant price discovery function, then the ECM will have to take a number of steps to regulate these contracts as SPIDCs, as Mr. Schultz explains in his statement. If the Commission determines that the contract does not perform a significant price discovery function, then there is no further action to be taken by either the Commission or the ECM. Thank you, Mr. Chairman.
Thank you, General Counsel Berkowitz. Mr. Schultz.
Good morning. As has been mentioned, in determining whether an ECM contract should be declared I'm going to use the term SPIDC here, throughout significant price discovery contract, Congress established 4 criteria which have been mentioned: price linkage, arbitrage, material price reference, and material liquidity. And as Dan mentioned, because these criteria do not lend themselves to a mechanical checklist, the Commission provided guidance as to how it expects to apply the staff to apply the criteria. Not all the criteria need to be present for a SPIDC determination. The criteria in some cases may be interrelated. Generally speaking, the arbitrage and price linkage criteria attempt to identify contracts traded on an ECM that are essentially lookalikes or linked to a contract on a DCM and have sufficient trading activity to affect prices on the DCM. The material liquidity criterion also attempts to identify contracts traded on an ECM that have the potential to affect prices on another market. The material price reference criterion essentially focuses on contracts that serve a unique pricing function for a particular location, product, or quality in the industry. Consistent with Congress's direction, the Commission rules provide for an annual review of ECM contracts to evaluate whether any of these contracts should be SPIDCs. Staff recommendations today are the results of its initial evaluation of all the ECM contracts. As Dan mentioned, the Commission rules establish a process by which ECM determinations are made. There's an announcement in the Federal Register, and when the analysis is complete, the Commission issues an order explaining its determination whether the contract is or is not a SPIDC. Following a Commission determination of a contract as a SPIDC, the ECM must demonstrate compliance with the core principles within 90 days for the first SPIDC and within 30 days for subsequent SPIDCs. The first contract that the Commission determined to review for a SPIDC was the Henry Financial LD1 fixed price contract traded on ICE. The Commission issued an order finding that that contract was a SPIDC, and ICE was required to demonstrate compliance with the core principles. Similar to the Commission's process for reviewing a DCM application, an interdivisional team was assembled to assess ICE's compliance with the core principles. Staff evaluated the ICE Rulebook, Compliance Manual, Participation Agreement, and related procedures adopted by ICE to enable it to comply with the core principles. Staff observed an on-site demonstration in Atlanta of the market and trade practice surveillance processes and separately reviewed ICE's technology, security, test procedures, and business continuity. In general, staff found that ICE had fully demonstrated compliance with the ECM SPITIC core principles. As a registered entity, the staff would review ICE as part of its regular rule enforcement review process to ensure its continued compliance. Staff now has focused on the remaining ECM contracts. The Commission issued Federal Register releases announcing its intent to undertake further analysis with respect to 41. As has been mentioned, 23 of these relate to natural gas traded on ICE and the Natural Gas Exchange. 16 relate to electricity, 1 is a refined petroleum product, and 1 is a carbon financial instrument cash contract. We have completed our reviews of the natural gas and carbon financial contract and have made recommendations that the Commission is considering today. Staff's complete analyses and recommendations are set forth in the Federal Register releases. The 23 natural gas contracts under consideration today are listed by 2 ECMs, the Intercontinental Exchange ICE and Natural Gas Exchange. ICE is an Atlanta-based company that provides a forum for trading over-the-counter derivatives and energy products, while the NGX is an Alberta-based company, is an energy exchange providing physical clearing and settlement for natural gas trades. The natural gas contracts can be classified in 2 categories. The largest group includes 17 basis contracts, where by basis we mean refers to the difference in the NYMEX settlement price for natural gas at the Henry Hub and the value of natural gas at another production, storage, or consumption center in the U.S. or Canada. Staff believes that 7 of these contracts meet the SPITIC criteria. Staff believes that the remaining 10 contracts do not meet the enumerated criteria. The second category of natural gas contracts includes specialized contracts that are flat price contracts that involve physical delivery and are essentially merchandising tools, as well as contracts that provide a more granular hedging mechanism for market participants. Staff evaluated all of these contracts considering the criteria. Each of the 7 natural gas contracts that staff recommends be declared a SPITIC is a locational basis contract that prices natural gas at a specific location other than the Henry Hub. These locations in Southern California, San Francisco, Northwest Rockies, Chicago, Houston Ship Channel, Waha, and the Waha Hub near the West Texas near the New Mexico border. While the specific details may differ, the Division's observations and basis for its conclusions are the same for each of these contracts. That is, the prices of these contracts are commonly used as a key source of price discovery for the cash market, and the contracts exhibit sufficient liquidity. Each of these contracts is a key reference price for natural gas at a particular location. The contracts offer additional pricing information not provided by the active NYMEX and ICE SPITIC Henry Hub contracts. That is, they provide critical information about the value of natural gas at a future point in time at a geographic point, each of which has unique supply and demand characteristics. These contracts also have significant open interest in trading volume and are widely used by cash market participants for hedging price risks. As an example, I'll consider the ICE SoCal Southern California Financial Basis Contract, which prices natural gas at the Southern California border. It's a major center for gas that flows to Southern California from West Texas. With respect to material price reference, the SoCal contract satisfies the material price reference criterion in the Act and in our guidance. The contract represents a delivery location that is a major trading center, distribution point, and consumption center for natural gas in North America, and the ICE price is referred to on a frequent and recurring basis when entering into cash transactions and when valuing natural gas inventories, production, and demand at that location. The SoCal border hub is not directly connected to the Henry Hub by an existing pipeline, and prices at the SoCal point can diverge from the Henry Hub price, reflecting local supply and demand conditions, such that a competitive market price representing the value of natural gas at that location is of much benefit to commercial participants at that location. The contract also has material liquidity. Our analysis of liquidity was multi-pronged. We considered the trading volume of the contract, number of trades per day, and open interest as indicators of a contract size and potential importance. For the SoCal contract and the other 6 contracts we recommend be declared SPITICs, we believe that staff found that each of these contracts met these liquidity thresholds. The other 10 contracts, natural gas contracts, which staff believes should not be declared SPITICs, include locational basis contracts representing smaller natural gas delivery locations throughout the U.S. There may be reasons why a particular hub is of lesser importance. One reason is that the relevant location is directly connected to the Henry Hub. As a result, the actively traded Henry Hub contract, either on NYMEX or ICE, provides a sufficient indication of the value of natural gas for market participants. Another reason is that there is another hub in that area that is dominant in terms of pricing. In view of these considerations, staff does not believe that these locational basis contracts meet the material price reference standards. In addition, there are several contracts that serve as specialized hedging tools for industry participants rather than serve as price discovery mechanisms. These contracts are generally used to adjust prices that are already locked in by hedgers or to modify previously established hedge positions or fine-tune delivery obligations. Price discovery usually is based on the NYMEX Henry Hub futures contract. Finally, there are several NGX contracts that are flat price contracts used to determine the price of physically delivered gas at locations in Canada. These contracts do not meet the material liquidity criterion, and in the case of the Alberta contract, the contract does not meet material price reference, as the ICE cash settled contract is more important to market participants as a pricing reference. In summary, staff has attempted to closely follow the guidance set forth by the Commission in evaluating each contract as a potential SPITIC. The full recommendations are set forth in the Federal Register releases demonstrating our analyses of these particular contracts and an evaluation of the comments raised with respect to the Federal Register releases. That concludes my presentation. Thank you.
I want to thank both of you for a remarkable amount of work on this. What I just want for my fellow commissioners, there's going to be 3 motions that we'll entertain. The first would be on the 7 contracts that are recommended, and then we would do questions and do the vote. Secondly is on the, I think it's 17, but I might be counted wrong, the natural gas contracts that you're recommending not be SPITICs, and we'll see what questions there are. And then thirdly is this climate contract. For some reason there's 3 votes, but this is, we're learning as we go. So the first thing, what's that?
Before we get into the specifics, I have some general questions to ask of the panel.
I'm told to actually entertain a motion, and then you'd have all the questions, but I could do it either way.
Well, it's not on
Then why don't
per
you
se. It's general
Right,
questions,
right.
if you would.
All right.
Please. General Counsel Berchkowitz, and I ask you this because you're all-knowing. At least that's what you tell us when you brief us. But I do know that you've been working on providing technical assistance in both the House and Senate on proposed legislation. And what becomes of ECMs under the proposed legislation that Congress is working on?
Under the House bill and the bill that is perhaps will be considered by the Senate if there's a motion to proceed, the category of ECMs would no longer exist. The various exemptions that are referred to in the statement would be repealed. But these facilities, these trading facilities, would be regulated as swap execution facilities under the legislation. And there would be core principles applied to the swap execution facilities would be required to abide by core principles under the legislation. So the CFTC, under this system contemplated by the legislation, would have at least comparable regulatory authority, if not some enhanced regulatory authority over these facilities.
Those core principles basically include the 19 that we have for SPITICs plus more. Is that my understanding that
I believe there's 9 core principles now that apply to ECMs, and I believe there would be additional core principles also applied to the swap execution facilities. So it would be ECM plus.
So in essence, if as these are approved, then there will be a continuation, as you see it, in future legislation. But even with a greater amount of oversight.
That's correct. That's correct.
I'm going to follow up just because I just want to clarify. And I see David Van Wagner there, so you can tell us how many core principles are in this swap execution facility. I mean, it's more than 9. In the Senate version that was 15. So I'm sorry, David Van Wagner's their general counsel inside of the Division of Market Oversight. But as I understand it, so that the provisions that Chairman Lincoln and Chairman Dodd worked out and released yesterday include 15 core principles, roughly the 9 that are in, plus another handful about public reporting is an instance, one of them. This real-time reporting is a key one. I also understand that though the exempt commercial market and the SPITIC 2H7 and 2H3 would be repealed, that for 1 year after the President were to, if this got to the President and he were to sign it, for 1 year there would be a transition period where the SPITIC regime would still continue for 1 year. Is that correct, Dan?
That's correct.
So
there would be a one-year
there would
transition.
be an overlap. And if I might, I would also say my reference in my opening statement, there still are people that want to find exemptions and loopholes to this swap execution facility language, whereby energy contracts, particularly in natural gas and electricity, are possibly exempted. And frankly, having served in a prior administration when the same sort of debates were going, these exempt commercial markets, which are going to be small, and Enron was going to have them, and certain members of the House and Senate were proposing those exemptions, it feels for me like deja vu when people are suggesting exemption for energy contracts in a very similar way. But I hope we can have the discipline and that Congress hopefully will have the discipline to learn from these lessons and not, in essence, repeal the Farm Bill provisions and then put in its place something that is full of holes.
You're tracking me very well, Mr. Chairman. Maybe I should ask you the questions rather than General Counsel.
No, I'm just trying to staff Dan.
Rick, my understanding that the review of all of these were based upon the quarterly reports that they were required to submit. So I am assuming that this is dynamic. Every time you get a new quarterly report, you will have a division or staff begin to look at these to see if they meet these thresholds. Is that correct?
Yes, and the Commission's rules require that all ECMs provide these quarterly reports of all trades that exceed a threshold of 5 trades a day, and there's some additional information that they provide, and that's really kind of initial information for us so that we know what's going on in these markets so that we can start evaluating them if there's certain contracts that start exceeding the threshold. And it will be an ongoing, I think Congress anticipated this would be an ongoing evaluation of contracts that that we've never looked at as SPITICs now, those that maybe the Commission may decide aren't SPITICs today, and even those that may become SPITICs. I think there's a process to continue to review that. I think it's in the statute that there has to be kind of an annual review, but it's something I think we would do on an ongoing basis because we do get this information regularly.
I was quite taken with your description of the interdivisional team that was put together to go out to Atlanta to look at ICE's setup. And could you amplify a bit on that? Who went and what you looked at and how much time you expended on that?
Yes, it was pretty much similar to the process that we use when we look at a new exchange. It involved a team leader in our market review group and representatives from General Counsel's office, DCIO, enforcement, the usual suspects, the people that have expertise in various aspects of an exchange's operation. It was a pretty thorough review of the rules that they adopted, and we went there and observed, had a demonstration of their market surveillance, trade practice surveillance systems, their ability to provide transparency, backup procedures, and all. So it was an exhaustive review, but it's pretty much the same type of review we do if we get a new application from for a DCM.
And for these the ECMs that would be designated as SPITICs, then there has to be follow-up to ensure that they are adhering to those core principles that are in there. And those will be done by RER's rule?
No, initially we would be working with if the Commission decides to accept the recommendations, these would be additional ICE contracts. So as I said, for many of the core principles, they've already adopted procedures or rules or whatever to come into compliance. So it's basically adopting additional oversight of these other contracts, and that's something we would be monitoring over the next few months to ensure that they do that. And then ultimately, if they come into once they come into compliance, we would on a regular basis be evaluating their ability to conduct self-regulatory requirements and monitor their rules with our rule enforcement review program, just as we would do with any registered entity, any regulated exchange. They would just be added to the list.
Okay, thank you. Those were the general questions that I wanted to hear.
Do our other commissioners have general before I do the motions, and then we have questions on the motions, but wherever Commissioner Malliot. I'm doing it sort of out of order, but
I'm happy to do it either way. I mean, I figure
no.
I'll answer my question one way or another.
Go ahead.
Mr. Schultz, as I understand it, none of the 23 gas contracts were determined to have met the price linkage or arbitrage linkage, correct? And all 7 of the contracts qualified under material price reference, and all but the Dominion South qualified under the material liquidity, right? As you noted in your statement, some of this criteria is more relevant than others, and clearly that's borne out in these determinations. I have 2 questions. Kind of one of the lessons learned, we've gone through 90 contracts. You've selected 7 in this one. We've done 1 previously. These factors, are they the right factors to be looking at? Obviously, we haven't, price linkage and arbitrage haven't become relevant. Why not?
I think the price linkage, there's a couple aspects of your question. The price linkage and arbitrage, I think, generally go to linked contracts. And I think that the general view was there if a contract is directly linked to a DCM contract, in a sense it creates a single market and warrants oversight. Or on the other hand, you may have a contract that's essentially like another contract, may not be linked, but through arbitrage it performs in the same manner, so that warrants oversight also. I think when you look at material price reference, you in a sense, you're looking at something that's different, and there may not be, and in many cases there wouldn't be a DCM contract to focus on, and in effect the ECM is providing the price discovery market, which is what we're saying here. So to the extent that occurs, the linkage isn't there, as well as the arbitrage, because there's really nothing to arbitrage to. You don't have the active DCM market. With respect to your other question, I wholeheartly agree. There's a lot we've learned through this process, and I think, as Commissioner Dunn said, we didn't really know what the universe would be when the statute was changed. And a lot of the thinking and rationale is laid out in the Federal Registry releases, and I think it would make a lot of sense for us to go back and possibly seek comment, either to codify or to put into the acceptable practices some of the analysis and thinking that we've done, and request comment as to whether there's other approaches that we could use and other criteria to consider or whatever. And the Commission, I believe, does have the authority to even establish additional criteria if they so chose. I'm not saying we're recommending that, but I think it's something we could go back and look at. And unless the legislation happens and makes this moot, I think it's something we would, I agree with you, it's something we'd want to go back and look at, lessons learned.
One last question. Going forward, we still have a handful of these contracts. I assume we're looking at the same standards and criteria, nothing out of the ordinary coming up?
No, yes, we're reviewing those. It's mainly the electricity contracts. We're looking at the same type of criteria. Again, it's a different market, but the same general standards.
Do you have a timetable on when that might be ready?
We hope to finish those in the next month or two. We've been looking at those pretty actively.
Just in time for the legislation to pass?
Well, yeah, that would be terrific, Rick. Just to clarify, the 4 criteria that both of you referred to and a number of fellow commissioners have, those were in statute, as I understand. Is that correct?
That's correct. Those are statutory criteria.
And the first criteria referred to linkage. The second is arbitrage. The linkage was what was the key criteria on the contract last year, the Henry Hub contract. Is that right?
Well, it was linkage, but also arbitrage. I mean, they price
Right.
very much the same.
So those were the 2 criteria that were critical to that.
Well, and I think also even the price reference, because it's such an active market
I
that
see.
people kind of go back and forth, in terms of pricing between the 2.
But on the 7 that you're recommending today, the key criteria is this material price reference.
That's correct, yeah. That's the fundamental point.
I don't know whether I'm supposed to do a motion, but
I have one more question.
all right. But I mean,
I'll see if
everybody can ask questions after a motion happens, too.
Just want to muddy up the water a little bit, Mr. Chairman.
And then Commissioner Chilton does, too.
The proposed position limit regulation that just closed, I'm assuming that these will be affected by that if, in fact, the Commission adopts that?
No, these wouldn't be included because we've looked at the main contracts, WTI crude oil, natural gas, and heating oil and gasoline, and the proposal doesn't really address these other types of maybe niche markets. I'm not saying the Commission couldn't consider that, but that wasn't. These aren't really substitutes for the Henry Hub natural gas contract. This kind of goes to the whole point of the material price reference, that they're different, pricing something else, so they wouldn't be included with those.
Commissioner Chilton, I guess for general questions, and then we'll go to the specific questions that I've already probably asked.
I'd be happy
mine.
to move that we accept the staff's recommendations on the 7 and then ask a question.
Great. So having heard a motion that we accept the staff recommendation on the 7 ICE financial basis contracts that I know have been outlined, do I hear a second?
I will second.
All right. Having a motion now being considered by the Commission, and I usually go in order, but why don't we just let Commissioner Chilton continue and ask his question, and then I'll go to Commissioner Summers because we've kind of done this out of order.
I'll be brief. For people looking on, I just want to, you've said this essentially, Mr. Schultz and Mr. Berkovitz, but some of us, obviously, the chairman and others support doing more of this additional regulation an oversight of markets that I've talked about in our opening statement. But we are constricted and confined by the laws. So we couldn't, for example, say, even if we had the support among 3 of the 5 of us, that we wanted all of these things to come under our oversight. The law simply doesn't allow us that flexibility. So even though we may have individual positions whether or not we support bringing the OTC markets under our regulatory purview, we can't do that given the constrictions of the SPIDIC legislation. Is that correct?
That's correct, Commissioner. The jurisdiction of the Commission is limited in this respect to these exempt commodities, and then the threshold for regulation is making the determination that they constitute significant price discovery contracts.
Okay. And I don't want to get into a big, long thing here, but I did want to, as I look around the room, and not only the folks that are helping Rick, they're meeting with me this morning, Susan, and Martin, and David, and Greg, but I noticed, Paul Ciccio's here, who helped work on this legislation, and John Riley, and you in particular, Mr. Berkovitz. I mean, if you hadn't done, when you were working on Capitol Hill, the Amaranth investigation, I don't think we would have this legislation and these important regulatory tools. So thank you very much.
Thank you, Commissioner Chilton. I'm kind of going out of order, but Commissioner Summers.
Thank you. I have a, I think, more general question with regard to what the benefit is for us as a regulator, these additional authorities that we will have over these 7 contracts, or the 8 now, that one that we've already determined, the additional regulatory authority or additional regulatory responsibilities that the exchange now has. If you could outline specifically some of the benefits you see in us making this determination.
I think in general, trying to figure congressional intent, it was that for contracts that are material in interstate commerce, significant price discovery, however you want to refer to it, that similar to contracts traded on a DCM, that those types of contracts would warrant similar oversight, so that the commission, well, not just the commission, but that the ECN, the exchange itself, would have responsibility to oversee trading in that market, to get information about large traders, to know and monitor activity in the market, to have the tools, rules in place to deal with issues, if emergency provisions and other procedures if there are problems identified, and I think more importantly just to be monitoring the markets to see if there are problems, because if they're not a SPITIC, there really isn't a self-regulatory oversight responsibility. So I think it goes to ensuring the integrity of the marketplace, because these types of instruments would be viewed similar to those traded on a DCM and would warrant similar regulation and oversight. And the same tools would apply both for the exchange as well as the CFTC.
I think more specifically, I would be interested in hearing, since you have experience with the one contract that we already made the determination on several months ago, are there specific things that were surprises to you as staff, seeing the information that you're now getting on this market, or the specific benefits that you're seeing from, I guess, maybe just particularly that one contract that you have experience with right now?
I don't think there's anything specific that was surprising. The one thing we have to work with is that ICE not being an intermediated market, our IT people have to work with them as far as getting the data in, the large trader data, to do the oversight. But that contract in particular had been the subject of a lot of comment and by the press and others for a long time. So it's something we had been looking at for quite a while. So it wasn't just beginning last year when we kind of were paying attention to it. So I don't think there's anything specifically noteworthy to mention.
Thank you.
I guess I'm going to do this in order just to see if there's any questions. So I think I had my basic question answered, but I just want to understand, because we're supposed to make this determination if any of these 4 criteria are met. It's not that all 4 are met, but it's any one of the 4 is met. Dan?
The statute doesn't say. The Commission can determine whether it wants to base its decision on all of them or some of them, and the various ways.
I see. But didn't we publish rules last year before I was part of the Commission? But I think there were rules. Did that give guidance on this?
There is guidance. Generally, the guidance reflects what I just mentioned, that not all the factors may be present. Some of the factors may not even be present. For certain of the factors, such as price linkage, just that factor alone, the Commission in its guidance indicated may not be sufficient.
I see. Okay. I'm comfortable that if one of the factors is met, that we move forward. I think, as Commissioner Summers laid out, 7 of them have that, and that's an important thing for the public to understand. I think that's, if we move forward, the Commission is affirmatively saying that this material price reference. We're accepting the staff recommendation. I had one other question is on, in looking, this may be true of all 7 of these, but on the SoCal one, this basis, locational basis swap, I understand from the Federal Register release that ICE, the actual exempt commercial market that might have further regulation, they submitted a letter saying they didn't think it should be a SPITIC. So, Mr. Schultz, if you can walk us through, just I think it's relevant to understand that. You might want to hit your mic.
Yeah, sorry. Yes, that's true. In general, we've just maybe to mention briefly some of the comments we got. We did receive comments from FERC and Platts. Both of the FERC comment was basically saying that it wouldn't appear to conflict, that declaring any contract as SPITIC wouldn't appear to conflict with their exclusive jurisdiction, so they didn't really opine specifically on the merits.
Can I just ask Mr. Berkovitz, do you agree that what we're doing here wouldn't affect what we think is their jurisdiction?
That's correct. What we're doing here would not affect the jurisdiction of the FERC.
Great.
Yeah, and we received a comment from Platts that they basically, because some of these contracts are ultimately cash settled on Platts prices, but again, they provided some good useful information about that process, but didn't really opine on the merits. We did receive some, like from the Industrial Consumers of America, saying that they thought the contract should be, actually all of them should be declared SPITICs without a lot of elaboration. Both ICE and NGX, as you mentioned, commented, and basically saying they didn't think they should be declared SPITICs, but a lot of their focus was saying that the ultimate cash settlement price, whether it be Platts or some other third party, was the price that people look to, and that it's a reliable and useful price. And we agree with that the settlement price that, using Platts or whatever makes sense, and it is a reliable price. But I think what we're focusing on is what derivatives do. I mean, you're trading, it's contracts for future delivery, and what do people look to the ICE or these other prices in making determinations about buying and selling in the future. So the fact that ultimately you're going to settle to, say, to a Platts price or whatever, we tend to agree, but it didn't really change our conclusion.
I see. So it's sort of like saying in the wheat market or in the corn market, until the settlement date, the derivative is a material price reference. But on the day of settlement, of course, the price of corn or wheat in Chicago or at a delivery point is probably, the relevant, if you have what's called convergence.
And another point was, and this kind of goes maybe a little bit of a peculiarity to natural gas, kind of if you look, you may take a very narrow interpretation of the material price reference and do traders specifically write cash market transactions that that say we're going to buy or sell at the ICE price. In general, that's not the case, because most of the natural gas industry has evolved such that all pricing is done relative to the Henry Hub. So you would never have a flat, a price that's a differential. You'd only get in part of it. So our view was not so much that it's actually quoted in an ISDA or some sort of a contract, but is it a basis for making a determination about what you want to buy or sell natural gas at. So that's...
Thank you. I take it you've read the comments. Your Federal Register release talked about this, but that was helpful for me. Commissioner, any other commissioners? Commissioner Amalia? Sure.
I have one question when we get to the point where we're the 16 that we're not.
Okay, so why don't we see? So we have a motion properly seconded before us to accept the staff recommendation that the 7 enumerated ICE contracts be determined to be SPITICs. If the commissioners are ready for vote, all those in favor of accepting the staff recommendation and finding that these are significant price discovery contracts will say aye. Aye. Any noes? Appearing that it is a unanimous 5-0, the staff recommendation is accepted. I'd like to entertain a motion on the staff recommendation to issue an order that specifies that the contracts so enumerated, I could list them all, but I have 5 NGX contracts, and I gather it's probably 11 ICE contracts in the natural gas market are not SPITICs. Does have a motion?
So move.
Any second?
Second.
So discussion.
I just have one question. Of these, Commissioner Dunn brought it up, Commissioner Summers brought it up. When ICE implemented the first SPITIC contract, they implemented the core principles. Are any of the NGX contracts close on any of the criteria that might trigger them to begin to implement the core principles on any one of those?
Some of them are closer, generally closer to kind of some of the thresholds we looked at. And again, as was mentioned, we get the quarterly reports. It's something we would continue to follow, and you know, over the summer and the fall, as we continue to evaluate them, then we might come back with a recommendation that a particular contract or two does meet the criteria.
Without putting you on the spot, can you tell us which ones are the closest to triggering this?
The Alberta basis and the Union Dawn contracts.
Thank you.
What is the Alberta basis contract? If that's the closest, why don't you, if you can, describe it and why you think it is not a SPITIC?
Well, currently the rationale is similar to what I had articulated before for the other contracts. Is that it doesn't have it's not the contracts aren't generally representing points that are as significant as some of the others, and that there may be ICE contracts or other contracts that at this time are generally the price reference point. And the contracts are also similar to those traded on ICE, so it's kind of which one dominates and becomes the more popular pricing reference.
And would it be correct, this is a general question maybe for both of you, or if David Van Wagner, I know, is close to this legislation, if the Senate, as Senator Lincoln's and Senator Dodd's bill were accepted, and with the House bill somehow became, law, but I'll just reference the Senate bill, would then, and this kind of goes to Commissioner Chilton's question, would all of these contracts, these 11 on ICE and maybe these 5 on NGX, we would no longer be debating whether there's significant price discovery contracts. That would be repealed. But would ICE, the ECM, and NGX then have to become swap execution facilities and have these 15 core principles or some, whatever Congress comes out with?
Yeah, they are trading facilities, so they meet the trading facility definition as currently in either of the bills, in the House bill or the bill before the Senate. I don't know jurisdictionally where NGX is located.
Yeah, they're located in Canada and Alberta, so I don't know if they would have some other...
Well, they may be a swap execution facility where we might be able to have some mutual recognition of some foreign regulator, but there would be that issue. But you're saying at least the ICE platform would be a swap execution facility as you understand it.
That's correct.
Mr. Chairman, just to follow up on that, it would mean, given this hypothetical situation that you described, that staff would, particularly given the constraints of our staff that Commissioner Dunn's talked about, that we would have to prioritize which ones of these things would be the most important for us to look at. But if it passed under the hypothetical situation the Chairman described, they'd all be included. That would be our world to try and deal with appropriately, right?
That's correct. That's correct.
But I think we wouldn't be prioritizing SPITIC determinations because we wouldn't be doing these individual, just the platform itself would then be regulated.
Right.
And we've actually requested, just so that I share, I mean, unfortunately the President put it in the budget, that this agency, which is a little over 600 people right now, we made an initial estimate for the Congressional Budget Office that we think we'd need to be at about 1,000 people.
Right.
to sufficiently and adequately perform the duties that the House was considering. The Senate duties might actually, make that even more.
Right. Well, the point that I was not eloquently making is that should we not get those FTEs and we are given this responsibility, that as far as market surveillance and oversight, the reason that some of these aren't SPITIC is not only because we don't have the authority to do it, because they don't trade, because they're only trading one contract or two contracts. There's no volume there. So that wouldn't take a lot to look at, but we'll have to prioritize if we don't get the FTEs. And that was my point. Not that we haven't requested it, and we'll commend the administration and the chairman for moving forward in that regard.
Any other questions on these 16?
Yeah, Mr. Chairman.
Yes.
Just a point of clarification. One of the public benefits that we get when a SPITIC is designated is we get the large trader reporting information. Can we still get that information through special call for those that are not designated?
Yes, we have the legal authority to do that.
Are we doing that?
No, we're not.
Actually, Commissioner, just to clarify, we have used the special call authority for ECM contracts. Prior to the Farm Bill, we actually issued a series of special calls to ICE for the Henry contract, which of course eventually was the first SPITIC contract. So I think we could dust off that special call authority if we wanted to use it for the non-SPITIC contracts.
Thank you, David. Not hearing any further questions. I believe we're prepared to vote. So if I could ask all those in favor accepting the staff recommendation and finding that the enumerated contracts are not significant price discovery contracts, can signify by saying aye.
Aye.
Any opposed? Seems like it's 5-0, and the staff recommendation is accepted. I don't know if there's a separate presentation on the climate. So, Rick, you want to tell us a little bit about this climate contract, and then we'll entertain a motion on it.
Okay, thank you. The other ECM contract under consideration today is the Carbon Financial Instrument, or CFI contract, traded on the Chicago Climate Exchange. The Chicago Climate Exchange was established to offer various environmental products. It's an only North American exchange that offers voluntary yet legally binding carbon-related products. That product is the CFI contract, a proprietary carbon allowance offset instrument which represents 100 metric tons of carbon dioxide equivalent. Allowances are issued to emitting CCX members in accordance with their emission baseline and ECCX emission reduction schedule. The CFI is a cash market instrument, not a derivatives contract. The Chicago Climate Futures Exchange is a subsidiary of the Chicago Climate Exchange that operates as a designated contract market, lists derivatives on the CCX carbon financial instrument, as well as futures and options on nitrogen oxide and sulfur dioxide allowances, and contracts on regional greenhouse gas RGGI allowances. In its Federal Register release, the Commission indicated that the CFI contract might satisfy material liquidity and material price reference factors. Based on updated trading data provided by CCX and further analysis, staff does not believe that the CFI should be declared a SPITIC now because it does not appear to meet the material liquidity or material price reference criteria. The Commission's decision to undertake a review of the CFI was based on the exchange's required quarterly notification, where 8 vintages of CFI contracts were combined. Subsequently, staff found that the CCX lists and trades each CFI vintage as a separate product and publishes a vintage-specific closing price for each CFI vintage instrument. Based on this information, staff analyzed each individual vintage of the CFI and determined that the number of trades per day only averaged about 1. That level of activity is well below the 5 trade per day reporting threshold that the Commission had established. With respect to material price reference, we note that the CFI is a Chicago Climate Exchange created product. The CCX designed all the parameters of its carbon emission program, and it established the rules for membership on the ECM for allowance trading and the creation of offsets. After our analysis, we have concluded that the CCX CFI does not meet the material price reference criteria for a SPITIC determination. in that regard, it appears that the CFI prices are not widely used as price references to the U.S. carbon market due to the relative small market share of this program to the overall U.S. carbon market, and given the currently limited potential for the CFI program to be folded into a national mandatory carbon reduction program. This recommendation or conclusion isn't an opinion about the merits of the CCX or its carbon financial instrument. It's just an evaluation of the trading there and how it's used relative to the SPITIC criteria. And for the reasons noted above, that our recommendation is that the Commission not find that the CCX carbon financial instrument is a SPITIC. And before I finish, I just wanted to make one more, something I forgot to mention before. I wanted to thank in the division and others who spent a lot of time on this, particularly Greg Price, who led the project, and Martin Murray, Susan Nathan, and David Van Wagner, and we'd also gotten a lot of support from the General Counsel's Office on Enforcement. And with respect to the carbon contract, Irina Leonova has spent a lot of time on that, who's basically become one of our emission experts. So I just wanted to thank them before I concluded. Thank you.
Thank you. And before I entertain a motion, I'm being told that technically I'm going to read the contracts that we just approved and disapproved, apparently. So if I garble any of these, I apologize, and the reading glasses are coming on. But the 7 contracts that we recommended and just so voted on all are ICE, but the first one is ICE Houston Ship Channel Financial Basis Contract. The second was ICE Waha Financial Basis Contract, West Texas. Third was ICE Alberta Financial Basis Contract. Fourth, ICE NWP Rockies Financial Basis Contract, which is in Wyoming, Utah, and Colorado. ICE SoCal, which means Southern California Border Financial Basis Contract. Next is ICE PG&E Financial Basis Contract, which happens to be near San Francisco, and ICE Chicago Financial Basis Contract. Those are the 7. And bear with me as I read these others because it's a long list. But the first 11 or so are ICE. San Juan Financial Basis Contract, ICE Malin Financial Basis Contract, ICE Dominion South Financial Basis Contract, ICE Henry Financial Basis Contract, ICE Henry Financial Index Contract, a little different. Next is ICE Henry Financial Swing Contract. It's not like swing dancing. No? Okay. Sorry for the press corps there. ICE Permian Financial Basis Contract, ICE TCO Financial Basis Contract, ICE Zone 6 New York Financial Basis Contract, ICE TETCO M3 Financial Basis Contract. You can see, if the public's listening, how technical this is. And ICE NGPL TXOK, is that Texas OK? Texas Oklahoma Financial Basis Contract. 5 contracts on the NGX exchange. Their AECO Basis Contract, was that the Alberta one you referred to earlier? Their Union Dawn Basis Contract, their AECO Fixed Price Contract, which I gather is Alberta, their Union Dawn Fixed Price Contract, and something called their 7A Index Contract. And I think I've just then officially read that into the record. If I could consider a motion or entertain a motion to accept the staff recommendation to issue an order that the carbon financial instrument offered by the Chicago Climate Exchange is not a significant price discovery contract.
So moved.
Second. The motion being properly moved and seconded. Any questions from the commissioners? I just had one, which was, Rick, you said there's 8 individual contracts and there's on average 1 trades a day. What's the total open interest of these, if anyone
I don't. I can ask Karina. In a sense, it's kind of open interest is kind of a concept that doesn't completely apply because it's not a derivatives market. So what's really outstanding are the number of these instruments, not like
So this
open
was
positions,
not a
'cause there aren't
derivatives
positions.
marketplace. I remember when we first put this out, some people were asking why did we put the determination out, was because it's an exempt commercial market apparently.
They have filed under 2H3 an exemption for this kind as part of commercial, and under the bill, it between, say, derivatives and cash instruments as potential SPITICs. It's a little strange.
They were in a commercial market, though these are not derivatives, it is a commercial market because they had come forward years ago and become an exempt commercial market.
They don't have to rely on the 2H3 exemption because it's a cash instrument, but they have chosen to do that.
But that's why I leave out, because there was more than 5 a day, but then upon further review, there's 8 separate things. But use doesn't have a material liquidity. It doesn't have a material price reference.
Correct.
Any questions, fellow commissioners?
I want to reiterate, thank you. I just want to reiterate something you said earlier, particularly with regard to this contract. We can review this all the time. Sherdun asks out quarterly. But say, for example, Congress did approve sometime later this year an energy bill. And even if it didn't include cap and trade, people may want to go and use a CCX contract, and we could see a spike in volume. So we don't have to wait for an annual review. We could make a determination later on that it is a SPITIC.
Yes, and again, that's with the purpose of getting the data on a quarterly basis. So if something does change, we can react to that.
Okay. And then the other thing, Mr. Schultz, I don't know if you wanted to comment on this, but earlier when we were talking about the 7, you said that Platts was a reliable pricing publication, and I just wanted to clarify. I mean, some people think, and forget about Platts in general, but don't think that that may be the case, that these things are debatable. But for us, they are things that are used as in the contracts, that they are published and people use them. So I just wanted to make clear, and feel free to comment, that we're not vouching for the authenticity of these prices that are put out there. Is that correct?
Yeah, I wasn't trying to make any judgment about whether the Platts prices in particular. It was just that what they were focusing on there was many of the comments about that it's the Platt price, it's the ultimate settlement price that's the
what people
price
look
reference. And we were saying, well, no, for derivatives, you're really looking for the future.
We're not saying that they're not.
Yeah.
Great. Thank you.
Not hearing any further questions. Maybe there is.
No, Mr. Chairman, I just, again, wanted to thank the staff for the good job that they had done. When you put all the material together, it's a stack about this high, and it took a great deal of effort by a lot of people, and I greatly appreciate the efforts of the staff to give us good information so that we can make correct decisions.
I'll thank you after the vote, but I don't mean that I'm not, well, we probably, but having a motion duly seconded, all those in favor of accepting the staff recommendation that the climate change contract not be considered a significant price discovery contract under the Farm Bill guidance, say aye. Aye. Any opposed? The motion carried 5-0. I, too, wanted to thank the staff for all of their work. I mean, it probably is correct that when this was first brought forward in the Farm Bill in 2008 and then a rule that came after it, that one was not envisioning this many contracts, but you've sorted through part of it. We still have 17 to go, right, on the electricity side. And I heard Mr. Schultz, you said in the next month or two. So this commission would be delighted, because it may be that a president is signing into law a major reform that we're going to need to focus on. So I thank you. I also want to thank my fellow commissioners, because I know each and every one of these contracts have been through your offices. And I thank you for indulging me on doing this in the public forum. But I think the more we do this, And I think if the president does sign in new financial reform legislation, that we're going to use this format sometimes just to learn, because we're going to have probably 20-plus rules that we're going to be, asked to do, sometimes in conjunction with the SEC, sometimes alone, sometimes in coordination and consultation. So that we might use this format just to learn a lot as we're going through that rule process. But I want to thank you. I don't know if anybody else. No. So not hearing any further business, I'd like to entertain a motion to adjourn the meeting.
I'll move.
Second. All in favor? Aye. The fourth unanimous vote. Thanks.